Good morning from Florida to all of you, and thank you once again for joining us from around the world. Today is Thursday, July 2nd, 2020, and this is the webinar about the latest visa ban executive order. Now, in case you're wondering about my location, some of you know that I, in addition to being your immigration attorney, serve as an honorary consul to the Republic of Austria, and because this is a secure and safe location, I am broadcasting from the Austrian consulate in Tampa today. Now, with this webinar, I'm going to try to get through the updates in 30 minutes or less, so I can leave plenty of time for you to ask questions about this subject matter. If you want to ask a question, there should be a function on your screen that allows you to raise your hand. And that's all you need to do. And when I call on you, there will be a function where you can unmute yourself and then just go ahead and ask your question, and we'll make sure that we can take as many questions as possible. Now, you know I'm your lawyer, so finally here's my disclaimer before we get going. Please do not take anything I'm about to say today as legal advice. It is really for informational purposes only. And I say this because this is such a fluid subject matter, and the goalposts are being moved constantly. So whatever I'm telling you today may not be true tomorrow. So don't act on what I'm telling you today. And if you want to act on it, please do check with us before you do, or with other competent immigration counsel. So with that, let's get going. First, the proclamations. You're all familiar with the original proclamation, which was published in April, effective April 22nd, which suspended the entry of certain immigrants. And of course, immigrants are people with a green card, people who are going to live in the United States permanently. So if you did not have your immigrant visa issued on or before the effective date of April 22nd, 2020, you were no longer allowed into the United States, with some exceptions, of course. Now, this new proclamation, the one that is effective as of June 24th, 2020, included the original proclamation and extended that proclamation until the end of the year. So everything that got restricted in April for the first 60 days is now extended until December 31st, 2020. And in addition to that, the new proclamation suspends the entry of certain non-immigrants. And non-immigrants are persons with visas. And the visas that are being suspended are the H-1B specialty occupation visas, the H-2B temporary worker visas, J-1 visas in certain categories. There's a total of 13, I think, J-1 visas, but the ones that are being suspended are for interns, trainees, teachers, camp counselors, au pairs, and summer work and travel beneficiaries, all L1A executives and managers, and all L1B specialty workers. And then all of the dependents of the ones that I just listed. So that includes all the H4s, all the J2s, and all the L2s. And what it means, if you did not have one of these visas on or before June 24th, 2020, you can't get one. Now, who is really subject to this proclamation? And of course, there's a lot of legalese in this proclamation, and I'm going to help you decipher that. Number one, if you were outside the United States on the effective date of that proclamation, you come within the purview if at that time when you were outside, you did not have a non-immigrant visa in the classifications that I have just mentioned, H-1B, H-2B, L1, and the J-1s. And finally, if you did not have an official travel document, I'm not going to read this entire paragraph, that really refers back to that first proclamation. But there's something interesting about the current proclamation, who it applies to and how it applies to you, because there is a little-known amendment to this proclamation, which the government hasn't really published or advertised. They published it, but they didn't really, make a big hoot about it. What they did is they closed a loophole in the original proclamation, Before the amendment, the proclamation read that if you did not have an immigrant visa that is valid on the effective date of the proclamation, so that would include all of the visas, a B visa, an O visa, an R visa, any visa. And after the amendment, it started reading and singling out the very visas that were excluded in the proclamation, the H-1Bs, the H-2Bs, the certain J-1s, and the L-1As, and the L-1Bs, and all the dependents. Now let me explain what that amendment really means. In other words, you must have had a valid H-1B visa, H-2B visa, an L or a J visa on the effective date. The effective date being June 24th, 2020. Having had another valid visa on the effective date, such as an F, a B visa, an O visa, an R visa, an I visa, whatever it may be, would not allow you the issuance of an H, L, or J. That is really the real amendment to the proclamation, because the old proclamation said before the amendment, if you had any visa, you could get a visa. Well, now you can't. If you didn't have a valid H, L, or J, you can't get one. Now, having had an H, L, or J and being outside of the United States on the effective date does not allow for the issuance of a subsequent H, L, or J. Now, what does that mean? For example, you were in the United States in H-1B status and your visa ran out and you had to go back home to get a new visa. So you left the United States before June 24th and you were still outside the United States on June 24th, but you had not gotten your next H, L, or J visa yet. Well, under the proclamation, you can't get it because you did not have a visa, a valid visa in your passport on the effective date. But on the other hand, having a valid H, L, or J and being outside the United States and the visa expires after the effective date, then the proclamation does not apply. Because remember, the proclamation says if you're outside the United States without that particular visa on the effective date. So if your visa, your old visa was valid on the effective date, but let's say it expired today on July 2nd, you could actually get another H, L, or J visa. And finally, the Department of State has notified everyone, sent out a memorandum that no valid visas will be revoked based on this latest proclamation. Now, let's talk about the exemptions, because I think that's really of interest to everyone. How, if I fall into within one of these categories, how do I get around that? We all remember from the first proclamation, of course, if you're a lawful permanent resident, in other words, a green card holder, come back home. If you're the spouse or child of a United States citizen, of course, you can come in. In the new proclamation, where we deal with the non-immigrant visas, there are various exceptions, and there's some that I want to touch upon because I think that we can help some of our clients with that. Now, any individual seeking entry to provide temporary labor essential to the U.S. food supply chain would be exempted from this proclamation. And we'll talk about that in a little bit more detail. And then an interesting section says, any individual whose entry would be in a national interest of the United States. And that's, of course, a very broad thing. And I think that we have some possibilities here for our clients as well. Let's talk about the U.S. food supply chain. There is not a person in this country that doesn't see at least a Walmart truck at least once a day. Those are our food supply chain truck drivers, and hats off to all of those. But even I, as an immigration attorney, know that driving the truck alone is not what the food supply chain is all about. There is way more to it than that. There's the production, the processing, retailing, logistics, consumer handling, disposal, consumption. It goes on and on and on. So this is a very, very vast industry with a lot of talent that is required. And just think about it. If you work for a company that is even remotely engaged in the food supply chain, we know that this requires software development. It requires software engineering, mechanical engineering, electrical engineering. There's lots of management consulting, installations of food processing equipment, technical support for that equipment, and so on. The list would go on and on and on and on. And I say this because we do a lot of H-1B visas for people in the US food supply chain, or H-2B visas, or L-1A executive and manager visas, or L-1B specialized knowledge visas. So give it some thought. Whether your business or you as an employee, whether the business you work for is somehow related with any type of service to the food supply chain. Because if it is, then you might very well come within the exemption, and I may be able to get your H-1B visa, your H-2B, your L-1, or even your J visa. The national interest is a big thing in the United States, and of course, you know, everything that happens here is supposed to be in the national interest, and there's a number of exceptions that come within the purview of that, but I don't want to touch on all of them. I want to talk about the ones that I think may apply to some of our clients. Of course, if you are a healthcare professional, and if you're engaged in the provision of medical care, whether you are a physician, doctor, a nurse, a registered nurse, or if you are engaged in research, if anything that you do in the medical field that has to do with solving this health crisis, the COVID-19 crisis we find ourselves in, then you will absolutely fall within the exemption, because it is obviously in the national interest of the United States to cure this disease. So if that is something that you do, then of course we can get an exemption, but beware, you still have to have a visa. You can't just say I'm a nurse and now I'm coming in. You still need a hospital to employ you. You still need a visa that is being applied for you, but we will in all likelihood be able to get that visa issued if you work in the medical field. A more interesting thing for many of our clients is the necessity, if you're facilitating the immediate and continued economic recovery of the United States. And I want to take a moment and talk about that, because I think that we can get waivers for that if we do it the right way. And the most important thing to know here is that the determination for such a waiver, for such an exemption, is determined by the consular officer, and it is discretionary. So whoever the consular officer in an embassy or at a consulate around the world may be, that is the person who at the end of the day might be making that decision. And as always in our immigration laws, you know, saying that I come within the economic recovery exemption doesn't mean anything. The burden is on you and me to demonstrate as to why that is. And I'll just give you an example of my thinking on how I approach these types of waivers. Many of you may have heard about BAHA, and BAHA is the acronym for Buy American, Hire American. If you have spent any time in the United States in the last 3.5 years, then you have heard about BAHA. BAHA is an executive order signed by the president. I believe it was January 2017. It was one of the first things he did. Buy American, hire American. And I can't say it often enough that everything that this administration is doing, unless they are subject to congressional legislation, if they can do it on their own, it will be under the umbrella of Buy American, Hire American. And if you read the proclamation of April 22nd, and if you read the proclamation of June 24th, and if you read the first 3 paragraphs, it's all, again, about Buy American, Hire American. So when we file a waiver like that, that is the first thing that we want to argue. Are we buying American with our business or when in this economic recovery, and are we hiring American when we do that? And for this purpose, let me give you an example. I like to take the EB-5 argument, and let me explain. Many of you know what an EB-5 is. It's the $1 million green card. That's how it's known on the street. A person can come here to the United States and, depending on circumstance, invest between $900,000 and $1.8 million, create 10 new jobs, and get a green card. The reason why I'm saying this to you is because if you read the first proclamation of April 22nd, EB-5 green card holders are exempt. So I'm saying if an EB-5 green card holder is exempt, then that is the threshold for economic recovery for me. Because if someone has invested around $1 million and created 10 new jobs, and they are exempt from the proclamation, well, then that is Buy American, Hire American, because otherwise that category would not be exempt. So now let's talk about your business, or if you are the employee in an American business or for a national-owned business, it doesn't matter who owns the business as long as it's located in the United States. How many millions are invested in that business? Well, I will suggest to you that in most businesses in America, there's more than $1 million invested. And in most businesses in America, there are probably more than 10 employees. So if the EB-5 is a threshold, well, then my argument is going to be, if I cannot bring my executive to the United States back to my business where we invested $6 million and where we have 36 employees, and I might be losing jobs here and contribute to the unemployment rate, or I cannot hire people because I cannot bring my technician in to fix a machine that has broken down, and so on and so on and so on. So I think there is a very a good argument to be made. As long as I can find a nexus between your job and the creation or maintenance of jobs in the United States, then I believe that we would fall into this exemption of contributing to the economic recovery in the United States. There are, of course, other solutions, and I want to share some of those with you. If you are Canadian, you already know you don't need a visa, an HL or J, to go back and forth between Canada and the United States, because you have a visa exemption. You still have to have your approved I-129, but when you do, you travel with that document and you're clearly excluded from the proclamation, and Customs and Border Protection has been notified of that, and they are aware of it. Another word of caution to Canadians: when you do travel, please fly. Do not use the land border. The land borders are still closed. Many people do not know about the automatic I-94 revalidation. It is also not affected by this proclamation. So if I'm in the United States, let's say on an E2 treaty investor visa, and my status is good, let's say until a couple of weeks from now, and my visa has already expired, but I still have this I-94 that allows me to remain in the United States for 2 more months, I can actually automatically revalidate that, as long as I have a valid I-94 when I leave the United States. However, you must leave to a contiguous territory only. If you are going to Asia or to Europe, that's the end of your stay in the United States. But if you leave to a contiguous territory, such as Mexico or Canada, and if you remain outside the United States for less than 30 days, you can re-enter with that same I-94, and your stay will be extended if you come back stateside. You have to, of course, apply to re-enter in that same classification. So if you're here on an H-1B, you can't try to come back on an F-1 or vice versa. If you're here on an E-2, you can't come back in on an R-1. So the classification has to be the same, but that's a very, very good way to beat some of those restrictions. It is, of course, still possible to change your status stateside, meaning if you're in the United States and let's say you are here on a B1 business visitor visa and you require an L1 because your business purpose has changed, or you require an H-1B because your business purpose has changed, or your H-1B has previously been approved but not issued, you can still change status in the United States. It has not been affected by the latest proclamation. There's talk in the proclamation to do something about it down the road, but I don't think that that will happen, and I will explain to you why. The president has almost unfettered authority to deal with entries to the United States, but he has little or no authority to change the immigration regulations stateside. You can't just say, this is what we're gonna do. No, that has to go through a regulatory process. There has to be some procedural regularity on how those things are done, or it has to be legislated in Congress. So don't expect that many changes stateside. That's the reason why you see so many changes coming into the United States, but not being in the United States. Now, when you change status stateside, of course, always beware the preconceived intent rule. And the preconceived intent rule is if you come in as a visitor and you conduct yourself inconsistent with the purpose of that visa, and then you say, okay, now I want to be an L1A manager, well, that is a preconceived intent. Typically, a preconceived intent goes away after 90 days, but beware of the fraud provision that's in that latest proclamation, because it says clearly in there, if you're trying to circumvent the non-visa issuance in any way by way of fraud, then that could have severe consequences. So we got to be careful about a change of status. That really requires some analysis and good review. There are other considerations, of course, and that is you've got to distinguish between the COVID-19 restrictions and the actual visa restrictions. And just because you have a visa doesn't mean you can't come in. For example, if you're in the Schengen area, I mean, we already know, well, we are painfully aware for many months now, that you have to self-quarantine somewhere else before you actually come stateside. There are waivers available from consulates if your trip to the United States is an emergency. But I always say, by the time you get a waiver, you might as well self-quarantine someplace. This proclamation, the first and the second, may they say what they say. Keep in mind that routine visa processing has been suspended until the end of the year. So whether you fall within this proclamation or not, or whether you're exempted or not, there is no visa processing. So anything that happens at a US embassy or US consulate abroad is by exception only. Another disturbing fact is that the USCIS is about, and maybe we don't know, but is about to furlough 70% of their workforce. And that's supposed to happen on August 3rd. And the reason for that is because, well, nobody's filing any visa applications, so they got nothing to do. And you may or may not know, but the USCIS stateside is self-funded. They are not appropriated by our Congress. So their money comes from the filing fees that you and I pay when we file applications. And if no applications are filed or not enough, then they can't pay their staff. So, of course, if those furloughs come about, there will certainly be, at least that's my prediction, an impact on changes of status or any type of benefit you're applying stateside, as it might take longer than it usually does. In addition to that, the proclamation calls for a 30-day review and then subsequent 60-day reviews. So stay tuned for any adjustments that we may see to the proclamation, and maybe something good comes out. But we, of course, don't know that yet. And I think with that, we are through our presentation, and let's go to our questions and answers. And let me figure out if we have someone there who is ready to ask a question. All right, Aliana.
Hi, Christian. This is Nikolai Safonov, and I don't know.
If you're on speakerphone, then please turn off your speakerphone and get on the phone.
Questions,
All right, in the meantime, we'll go to Srivadam.
what?
Hi, Chris. My name is Sri. I'm working for Dr. Maskin. We spoke for about last year, I believe. I work for a non-profit organization in an ophthalmology clinic, and we were setting up a clinical project in affiliation with the University of South Florida. And when the paperwork was about to get complete, the COVID hit. And only now the university is slowly opening up. And I want to know if it is a good time to proceed ahead with the nonprofit H1 filing.
Yes, Sri, I would say yes for two reasons. Number one, if your H1B comes within the purview of the medical research, then my answer is of course yes, because we can get an exemption for it. And secondly, whether the university is fully opened up is of no relevance in this case, because the Immigration and Customs Enforcement is continuing to allow all universities to conduct online courses. So whether the university is actually open, it will be considered open as long as online courses are taking place.
Okay, is there a good time me and my employer can speak with you and discuss further details about this?
As always, just reach out to Liz and I'll be happy to consult with you.
All right, thank you.
Thank you.
Yeah.
Okay, Aliona, let's try again.
Can you hear me now?
A little better, go ahead.
Yeah, my name is Nikolai Safonov, and before I go to my questions, I just want to thank you, Mr. Zeller, and the entire office of Manny Gordon. And
unfortunately, your I really appreciate the accolades, but the connection is so bad.
I think we're gonna to citizenship service. So my questions are: first question is executive order can be extended indefinitely? So how many times it can be extended?
Well, my guess is as good as yours. I do not think that an executive order is going to go on indefinitely. You will see lawsuits coming up fairly quickly on that. Can there be an extension on this executive order? Certainly. Can there be changes to it? Yes, absolutely. But I just can't comment intelligently on what this administration is planning on doing. But an indefinite stop of entry of visas or green cards to the United States is highly unlikely. I do not think that that would come within the purview of our laws.
Can a restaurant be considered as a part of food chain supply?
I don't think so. A restaurant is the recipient of the food chain supply issue. You're not contributing to the food chain supply. Well, you are in terms of the consumption and disposal, but I do not see, I just can't see that, since our restaurants are actually scaling back and shutting down instead of opening up because of the pandemic. So I do not see that that would be an exemption. All right, Francisco.
Hi, how are you?
Francisco, go ahead.
Thank you. You listen me?
Yes, go ahead.
Oh, my question is the proclamation, the last regulation, any law or any issue affect the permanent resident or no?
No, it does not. If you are a permanent resident and you're outside the United States, Francisco, you can enter at any time. Or if you are in the United States right now and you are a permanent resident, you can go, of course, you can go ahead and travel. Just make sure your green card is valid. But on the other hand, be careful on where you travel to, because coming back may be an issue, not because of your status in the United States as a green card holder, but because of the COVID-19 travel restrictions.
Okay, no, it's no problem.
It's not a problem.
Oh, thank you.
Thank you, Francisco. Kathleen.
Hi, can you hear me okay?
Yes, Kathleen, we can.
Great, thank you. So I work with one of your awesome immigration lawyers in the Satellite Immigration Help Office, right closer to the airport.
Okay.
Good. And we've been in the middle of a 3-year process to immigrate my stepson from Brazil. And we were in the final stages where we were waiting basically to get notification of his interview at the consulate in Rio. And so I'm just wondering how this affects family immigration. Can we assume that he also would be stalled and there would be no further processing of his application between now and December, or are they moving forward on family visas?
That's a good question, Kathleen, and I think you're dealing with a twofold issue here. One, the consulates are being having closed, and then the travel restrictions that we currently deal with from Brazil. However, I will say, if you take a look at the exemptions of the second proclamation, there is an issue about the Child Status Protection Act, where we want to see that children who are outside the United States and who are petitioned for by U.S. citizen parents or step-parents do not fall out of status or do not age out, as we call it. Now, I don't know how old your stepson is, but he's not going to age out under the immigration laws because he's absolutely exempt. But right now, the National Visa Center is not scheduling any appointments in any of the consulates.
Yikes. Oh, yeah. So he was 16 when we started, and now he's 20, if you can imagine, because it's just been taking so long. So,
well, the age out, Kathleen, of course, takes place with the 21st birthday. But it is interesting that you mentioned that, because your son specifically falls within that exemption, because children are not going to age out under this proclamation. I would ask that that you send me a short email about the circumstance, and I get our crew to follow up on that. I'm a little hesitant in discussing a very specific
yeah, I know,
understood, in a public forum because of the attorney-client privilege that you or your family, of course, enjoys with us. But rest assured, we're going to get the kid here.
Okay, good. So then 2 final things. Would you put your email in the chat box for us? And then also, essentially what you're saying in a general sense is that at this point, no interviews will be scheduled, we could say, through December because of the approach our government is taking. And so we can't expect to try to expedite things like this, or
this is the latest. This is the latest we know. However, the proclamation says, there's a 30 and 60-day reviews on it. So this might certainly change. We're just not sure whether it does. But with your child aging out, I think we have we come within one of the exemptions, and we may be able to get our foot into the door in Rio.
Fantastic. Okay, great. So if you could share your email, that would be awesome, and I'll be happy to email you more details.
All right, I'll be happy to. Thank you.
Okay.
Agnieszka.
Hello, sir. How are you?
Good. Go ahead.
So I'm waiting on for over 2 years for the fiancé visa. My fiancé is from Cuba, and finally in January they scheduled the embassy in Guyana for him, and we was waiting for the immigration interview. And now, when COVID happened, everything was delayed. So I don't know what is our options now.
Unfortunately, at this point, you're going to have to wait it out. We have dozens and dozens of clients on waiting on K1 appointment. It's really a function of the consulates reopening. And I do not think, Agnieszka, that a K1 would come within the purview of an exception or an exemption. Because at this point, the exemption would only be the spouse of a United States citizen, but not the fiance of a United States citizen. I mean, I do not want to suggest to you to go to Cuba and get married, but that would certainly put you within the purview of the exemption. But even then, you would have to file new applications, to go ahead with that application.
Well, when I start the process, my lawyer told me that, fiancé visa is much faster than is around 8 months when I first went in 2017 to ask questions, and to not get married, because that process is over 2 years and will be less than the year to get him as a fiancé. And is
Well,
that
I'm sorry that you experienced this long wait. You know, I pride myself to have a 100% success rate in being wrong about government processing time, so I don't quote it. But in this circumstance, you know, I don't think you'll find anyone to give you an intelligent answer as to when the American interest section in Havana is going to reopen to deal with K-1 visas.
okay? So till December is nothing.
Again, there are 30 and 60-day reviews of the proclamation. Right now, there will be nothing until December, but that could change in 30 days or that could change in 60 days.
Thank you so much.
Thank you. Shui.
Hi, I have a few questions. First is, you mentioned that if you had a B1 visa, then it was possible to change the status of your visa, change of state.
Yes.
Of your visa, right? But what if right now I'm outside US, I'm in the UK. So can I enter the US on my B1 visa, which is valid for another 10 years, and then change it to H1B? How does that work?
Well, you're dealing with the travel restrictions from the UK, so you probably have to quarantine 14 days elsewhere before you come stateside. But yes, you can come in with a B1 visa, but not under a preconceived intent. Now, applying for an H1B visa stateside to do a change of status would only be possible if that H1B is cap exempt. In other words, you know, it's
yes. So we started this procedure with New Mexico State University to join as an assistant professor on tenure track. So we have our I-129 approved, our LCA I-129, and I have my F797 form with me. But that was approved, and I couldn't just get my visa interview because of the embassy.
I think we can resolve that. I recommend that you, since you're from NMSU, that you call Tim Reardon in our Albuquerque office, and he'll walk you through the process.
Okay, so that would be fine. The last thing was, in terms of national interest, are professors considered, or professors who are starting in the new year considered under national interest?
Well, I think, with all due respect, that'll be a discussion for another day. You know, just having the title professor is not going to be in a national interest. But as you well know, we have done many national interest waivers for professors. It really depends on your skill set and your field of expertise. And I don't think that this is the forum to determine that.
Okay, that's fine. Yeah. Thank you.
Thank you for calling in. We appreciate it.
Thank you.
Andrew.
Good morning. Thanks for taking my call.
Sure, go ahead. I
just have a question about landed immigrant visas. Are those covered under either of these proclamations? And so I completed my interview, and then COVID happened, so I'm in a holding pattern. Am I on hold till the end of December?
Well, the term landed immigrant refers to Canada. Explain to me what I do not understand your question.
I have a DS-260 application.
So you're an applicant for a green card stateside.
Right, to go to see my spouse. Yeah.
So that was your U.S. citizen spouse petition for you?
Correct.
I think that we could potentially try to get our foot in the door at the post in Montreal, because spouses and children of U.S. citizens come within the exemptions of the original proclamation of April 22nd. But your immigrant visa, of course, has not been issued at that time. We can give that a try, but I can't guarantee the outcome of it.
Okay, so
has anything been scheduled for you, or you just completed the form and submitted the form?
I went through the whole interview process. I was missing one document. I submitted it, and then the visa office closed to receiving any new mail and at the COVID point. So,
and was that before April 22nd?
Yes, I had the document before April 22nd. I sent it in, but it was at that cutoff point. So I'm not sure where they are with going through their mail and looking
We'll
at
be happy to
documents.
we'll be happy to take a look. I think you ought to reach out to us directly so we can do a review of those documents. I have this feeling I'm not speaking intelligently to you unless I see the documentation.
Okay, fair enough. Thank you very much for your time.
Thank you. Rachel, are you there?
Yes, can you hear me?
Yes, go ahead.
I want to thank you for your time and helping us. My fiance, we submitted the I-29 before all this, and we're seeing that they're going through like the application. I can see the dates going down. So what I was kind of confused about is there, like we might get the I-29 approved, but then we're going to run into issues with the visa?
You're exactly right, Rachel. The I-129 is, of course, processed stateside with the USCIS, and the processing stateside continues. We'll have to see what happens once the I-129 is approved, but the National Visa Center is ready, to go ahead and schedule appointments at the various consulates. And when I talk about the various consulates, Rachel, we can't put them all in one pot. There's a good chance that one consulate opens up sooner than the other. I think that's going to be country specific, but I won't have a real answer for you until we have that approval for the I-129. We'll have to determine at that time then what the circumstance is. If your I-129 were approved today, well then of course, my answer will be, I'm sorry, we're in a holding pattern.
Okay, so is there any idea, or did they talk about when they would open it up in France, or what is going to be happening like in Paris, like when the US Embassy would be opening there?
Well, as you well know, that the entire Schengen area has gone into a phase of reopening, but that does not mean that our embassies will reopen. But I think it's encouraging that the Schengen area, is trying to find some normalcy in terms of doing business, which is of course important with respect to the travel restrictions and whether those might be lifted by the United States for Schengen area travelers, we don't know. But at this point, I have no indication that our embassies are going to continue visa processing. Although our embassies have gone into what they call phase 1 of reopening, but the phase 1 only includes United States citizen services and not services for anyone else.
Is there any timeline with that, with like how that would go about of reopening these consulates, like what phase 1, phase 2?
There is not, Rachel, and there's a real conflict also because the proclamation says there's not going to be any visa processing until the end of the year. So whether the consulate is open and whether there's visa processing is going to be two different things.
Okay. Also, with all the layoffs, is that going to affect the processing of like the visa, the I-129 and stuff due to all
no,
the
Rachel, it will not. Your application is based upon a relationship that is likely to go into end in marriage and has nothing to do with the economic circumstances stateside.
Okay, thank you.
Thank you. Guillermo.
Hello, Chris, can you hear me?
Yes, I can.
Good morning, and thank you for holding this conversation for everyone as fast. My current situation is the following. I'm married to a U.S. citizen. I'm currently holding a temporary resident card, which expires on March of next year. I wonder if, given the current situation that they are not holding interviews and everything is closed, am I going to face any issue by the end of the year? Because I think I have to submit a request to extend that green card by December this year, roughly, right?
So let me make sure I understand, Graham. You married a United States citizen, you got your first 2-year green card. Is that what we're talking about?
Yes.
Yeah, just file the application on time. Remember, that needs to be filed within the 90-day window immediately preceding the expiration of your temporary card. So no, there is no handicaps with that at all at this point.
Thank you so much, Chris.
Thank you.
Appreciate it.
Fiona.
Hi, Christian. Hi. I've got a question in light of the entire COVID situation. What is your view on the ability to file for an investor visa in the coming year or two? Obviously, potentially one of the interesting aspects of that could be employing Americans with whatever business you buy. And that might be interesting under the BAHA that you mentioned. But otherwise, do you think that in terms of processing times with the USCIS furloughing so many workers and there being such a backlog of existing cases that have to be gone through and processed, what is your view on the potential for an investor visa to actually come through successfully in the next year or two?
I think those chances are good, and you're absolutely right. E2 treaty investor visas falls squarely within the BAHA rules. There's no question about it. Also, don't forget, Fiona, that an E2 treaty investor visa is a bilateral agreement between the United States and other countries, in your case with Austria. So this is an interesting thing. It's just like the EB-5. You're investing money and you're creating jobs. There is no question about it. And by the way, you know, the embassy in Vienna is accepting these applications right now. They're just not processing them. You know, we have submitted E2s and it works just fine. You get a case number and off it goes. We just can't get anything issued at this point because of the closures. Now, I'm not sure what opinion I'm going to have on the backlog that these embassies are dealing with once they have reopened. I think, though, that the backlog may not be as big because in the last 4 months, no applications have really been filed. So there may just be a continuation of what is going on. But of course, you know, my guess is as good as yours. But I feel strong and bold about any E2 or E1 visa application.
Okay, great. Thank you very much.
Thank you. Greetings to Vienna.
Thank you.
Come on.
Hello, can you hear me?
Yes, we can.
Okay, perfect. So my question is regarding the adjustment of status as well as the green card. So by next month, my wife is gonna help me apply for a green card, and currently I'm still on OPT and it's ending next year. So next January actually, and starting August, we're gonna send out the application. So since you mentioned that we're gonna have like less employees at USCIS, so do you think that this adjustment of status could take even longer? And do you think that I would still have to go back if they don't get to my application before the end of my OPT?
No, because you're in OPT, once your application is filed, you're in an authorized period of stay authorized by the Attorney General, and you can remain stateside. It doesn't matter how long that application is going to be pending. So you're safe on that. And on the other hand, you know, with any application like that, you can apply for employment authorization. And once that is issued, at the end of the day, it doesn't really matter how long the actual green card application is going to take. You're going to be landlocked, obviously you're going to have to stay here, but you can work and go about your business. But the sooner you can get that application in, the better. And I say this because you're still in OPT and you have good work authorization, and you don't want to create a gap in work authorization eligibility. So the sooner you file your relative petition, the better.
Okay. So that means the adjustment of status is basically the same as the work authorization, is it?
It's not.
It's
not, but you want to apply for the whole thing all at once.
Okay. The work authorization, is it going to be a separate fee, or is it? Okay. Okay. Perfect. Thank you very much.
Thank you, Emma. Geronimo.
Hello, this is Geronimo's wife. Can you hear me?
Yes, we can.
Okay, so my husband is a physician here in the US, and he has an H-1B visa, and I have an H-4, but currently the stamp is expired, but the I-94 is valid. Can we renovate our visas, or
There's no point in renewing the visa. I mean, just stay stateside. All you need is your I-94. Remember, the I-94 is what authorizes you to remain in the United States. The visa is merely, you know, the document that allows you to come and go. I would absolutely not go overseas and try to renew that visa. That makes no sense whatsoever.
Okay.
Let me say this again. Do not go overseas and try to renew that visa.
No, but can we go to Mexico, like to go and visit family, or we should avoid that?
Well, that depends on how long that visit is. You know, you come within the automatic revalidation as long as it's less than 30 days.
Okay, perfect. And right now we are in the process of getting our green card. Is this process, is it going to take longer, or this is to stop right now?
I have no opinion on government processing times, but I'm also getting very concerned about where this question is going, whether you can travel while you have your green card application pending. I don't know what the status of your green card application is, so I'm going to go the safe route, and I say you're not going to Mexico. And, and if you want me to be more specific on that, then feel free to reach out to us directly, and we'll assess your specific case in your particular circumstance.
Okay, but our green card process can be continued even with the COVID restrictions?
Yes, it can.
Okay, perfect. Thank you.
You're welcome. Lindsay. Lindsay, are you there? Niveen.
Hello, can you hear me?
Yes, we can.
Yes, I'm a client of yours actually, and we've submitted for a change of status. A couple months ago, I did my fingerprints, and currently I don't know what's happening, and I'm not sure what's next. And if I guess you answered my question with a previous colleague. You said that you don't know the processing time now with the government, but I was wondering if
time, I don't know, Naveen. However, you know, if you're one of our clients, please do reach out to me directly, or to the attorney or legal assistant who's handling your case. I want to give you as specific an answer to your question as possible, but that would require us to take a look at your file, and in this forum, I don't think that will be appropriate to share your personal application with all the other listeners.
Awesome. All right. Thank you. Thank you very much.
Thank you. Bettina.
Yes.
Hello. Bettina, we can hear you, but we can't. If you're on a speakerphone, get off the speakerphone or get closer to the mic here on. Well, it's unfortunate we can't hear Bettina. See if there's someone else. No, that's it. So thank you to all of you for joining us. And if you have any additional questions, you know where to find us. I think we're going to put an email address in the chat box. And so if you have a questions, then feel free to reach out to us on that. You give me a moment. I'm just trying to get the right email address so we can also actually answer your question. All right, so there you have it. Here's the email address if you have any more questions. Thank you again for listening, and I look forward to broadcasting to you soon again.